The Evans Family Law Group, providing a full spectrum of family law services.
If you're subject to a court order that requires you to pay child support or alimony in Texas, it's really important for you to come and hire an attorney and talk about and evaluate your options. If you lose your job and you're unable to meet your obligations for child support or alimony, it's really, really, really important to come and take proactive measures to petition the court the minute something like that happens. Don't wait for 6 months to click off. And the reason why is because the court can't change what it previously ordered. And so if 6 months click off and you owe $1,000 a month, the court has no choice but to enforce the obligation that you owe for those previous 6 months. So in the second month or the first month or immediately following a termination notice, it's important to start bringing that to the court's attention. Even if all the court does is give you some temporary relief, at least on a temporary basis you can get some relief, and it's possible that you won't have that ongoing obligation that would then get stacked on top of you for a judgment. In the event of an unemployment situation and an ex-spouse files to terminate their child support obligation or an alimony obligation, it's really important to know that the courts typically will look at the history of the employment situation with that ex-spouse. They're not simply going to, in my experience anyway, the courts don't simply say, oh, you lost your job and your kids don't eat anymore, and your kids don't use your utilities and they don't use your gas and things when you're transporting them back and forth. The courts will look at the entire situation and will say, hey, you need to continue supporting your kids, but they oftentimes will provide some temporary relief. And it's important to know that that is temporary, and the courts will look at the entire history. So if somebody changes a career because of a forced job loss and they're now a baker, whereas they were an attorney or a professional career before, the courts are going to look at the differences and look at what they're capable of earning. And the courts can establish child support based on what the court deems as the ability of that person to earn. So if that person has the education and the previous experience and qualifications to earn $100,000 a year, but is intentionally earning $30,000 a year, the court may in fact deem the child support based on a level of income at, say, $90,000 a year or $80,000 a year. That's a situation where the courts may deem someone is intentionally underemploying themselves, and will set the child support based on what that person is capable of earning.
When life's path takes an unplanned turn, call the Evans Family Law Group for a consultation at 628-2550. The Evans Family Law Group, providing a full spectrum of family law services.